Now to introduce our presenters, I'm very excited to welcome Dr. Celia Fisher, who is a professor of psychology and Marie Ward Doty University Chair in Ethics here at Fordham, where she is also the founding director of the Center for Ethics Education, as well as READY, and she's also the PI of Fordham's Human Development and Social Justice Lab. Her work spans a wide range of issues, including professional ethics, research ethics, and health disparities, among others. The Human Development and Social Justice Lab focuses on issues of stigma, identity, health disparities, and the role of personal and systemic experiences in daily life, exploring these experiences within underserved adolescent groups, such as BIPOC youth, LGBTQ+ folks, and individuals with a history of mental health and substance use conditions. Dr. Alison Reiheld is an associate professor of philosophy at Southern Illinois University at Edwardsville. She specializes in ethics and value theory with a focus on medical ethics and feminist philosophy. In addition to her research on ethics of memory, Dr. Reiheld's work covers a broad array of issues, including disability, gender, transgender, reproduction, civility, unified by concerns about how power operates upon vulnerable persons in social institutions, including healthcare settings. And so now I'm just going to say a tiny bit about our format. So we'll start with brief presentations from our panelists, and then we'll kick off a conversation between them. And we do hope that all of you will be part of this conversation as well. For tonight's discussion, we will be using the private chat feature for audience questions. So to submit your questions, please submit them as a private chat to me as the moderator, and I will ask questions on behalf of the audience. So we encourage you to send your questions at any point during the conversation. And now, with no further ado, I will pass it off to Celia. You are muted.
Am I sharing my screen?
You are not sharing your screen now.
Okay, so. Sorry. Okay. Now I'm showing the screen?
Yep, we can see it.
Okay, great. Okay, so today I'm going to talk about human rights and the involvement of psychologists in death penalty cases. I'm going to divide my talk up into 4 different areas. The first, I'm just going to briefly talk about the legal history of death penalty. Then I'm going to talk about the roles and responsibilities of forensic psychologists in death penalty cases. I'll move on to the example of how the American Psychological Association dealt with human rights and psychologists' involvement in post-9/11 detainee interrogations, and then move to ethical arguments for and against psychologists' involvement in death penalty cases, also drawing on that post-9/11 experience. So what is capital punishment? I'm not going to be talking about the ethics of capital punishment per se, although certainly what I'm going to talk about is going to overlap with that. I'm really going to be focusing on why psychologists should not be involved in capital punishment cases. But in general, capital punishment is the legally sanctioned practice of killing people as punishment for certain crimes. In the United States, the death penalty cases are almost exclusively for the crime of murder. Some of the moral or attempted arguments for the death penalty include the fact that it's a deterrence against future murders and crimes, that it protects public safety, and that it allows for retributive justice. General arguments against the capital punishment is that it hasn't worked as a deterrence, that there are alternative mechanisms for public safety, and that we should value the intrinsic value of human life. Okay, so one of the first legal challenges, and these are all Supreme Court challenges, to the death penalty was Furman versus Georgia in 1972. The NCCP challenged the constitutionality of the death penalty under the 8th Amendment, which prohibits the federal government from imposing cruel and unusual punishments. The Supreme Court ruled that, in fact, the Eighth Amendment applies to all states, but the death penalty is not a per se Eighth Amendment violation. Rather, the death penalty can be considered constitutional if juries are given standards to guide them in their sentencing of deliberations. So basically, there were no death penalty cases for 4 years following Furman versus Georgia, but during that time, states were working very hard to develop standards so that death penalty cases could occur. So there are increasing Supreme Court cases that increase the involvement of psychologists and psychiatrists in death penalty cases. First, in 1976, there was Gregg versus Georgia that said that during sentencing, capital cases must consider psychological factors that would affect jury decisions. For example, did the defendant understand the reason they were being executed? And was there a probability that they would be violent in the future? Then in 1986, Ford versus Wainwright decided that insane inmates cannot be executed. In 2002, there was Atkins versus Virginia that said that the use of the death penalty for defendants with intellectual developmental disorders, formerly called mental retardation, was unconstitutional. Then in 2005, the death penalty for juvenile offenders was prohibited, and this was largely due to amicus briefs by the American Psychological Association about the fact that juvenile offenders were not able to understand the reasons for their crimes, that they were impulsive. Then in 2007, the death penalty was prohibited if assessments indicated the defendant does not understand the reason for imminent execution. And then in a more recent case, Hall versus Florida, it was decided that states could not have a strict cutoff point for determining whether somebody had intellectual and developmental disabilities. So, how are psychologists involved in death penalty cases? Well, they're involved in psychological assessments related to a jury's determination of two things. One is whether or not the defendant is guilty. Okay, so during that part of a criminal procedure, the psychologist is there to determine whether or not the defendant has the ability to stand trial. Do they have the cognitive ability? Do they understand what they're going through? Can they respond to their attorney? And whether under current law they can be tried in a capital case, that is, are they criminally insane or do they have IDD? The second phase of psychologist involvement is determining sentencing. That is, whether or not the defendant who has been found guilty can be executed. Here, the psychologist evaluates the defendant's ability to understand that they will be executed and the likelihood that they will commit a similar crime in the future. So it's important to know that the client is the court or a defense or prosecuting attorney. The forensic psychologist client is not the defendant. The primary responsibility of a forensic psychologist is to advocate for the facts by providing the judge or jury with information needed to make determinations only about the legal question at hand. They are not there to advocate for the defendant. So let's find out a little bit more about the insanity defense and some of its moral challenges. So the legal definition of insanity: defendants are not responsible for their actions if at the time of the criminal act there's an episodic or persistent psychiatric disease that existed before or just occurred at the time of the act, that they were unable to distinguish fact from fantasy or control impulsive behaviors, or they were unable to distinguish right from wrong. Now, not every state adopts all three of these criteria. For example, some states do not adopt the ability to distinguish right from wrong. But so what are the ethical challenges for a psychologist in terms of evaluating this insanity defense? First, it's difficult to gather history to reconstruct the mental state of a defendant at the time of the alleged defense. In addition, psychologists can only infer the defendant's state of mind at that time of the crime or at the time of arrest. And so the question is the psychologist more qualified than the juror to make that kind of inference? Other ethical challenges for assessment of criminal insanity is that the Bible of psychiatric and psychological diagnosis, which is the DSM, is not specific to definition of criminal insanity, which I just listed those three different factors. It has very little to do with if you're bipolar, if you're schizophrenic, if all the different diagnoses that are in the DSM. When you're interviewing a defendant, the defendant or collateral informants may have poor communication skills. And so you may not be able to get sufficient information about their state of mind during the crime. Defendants may lack cooperation, either told by their attorney not to cooperate, or they're just angry or do not want to cooperate, which also makes it difficult to make an informed decision. And psychologists also have to testify to the truthfulness of a defendant's response. Typically, that's called, if a defendant is not truthful from a psychological perspective, it's called malingering. And that's whether or not the defendant is over or underestimating their symptoms. Now, the problem with measuring malingering, as are a lot of other psychological assessments, is that they're very specific, standardized instruments that may be objective and reliable, but they're not individualized, they're not personal, and they're not contextual, and they may not even have been developed with the population that's being accused of the crime in mind. Additional challenge includes the fact that defendants with severe symptomatology are transferred to a psychiatric institution for treatment until such time as they can participate in a trial. And psychologists do not always have the opportunity to compare the defendant in their medicated and unmedicated states. And in addition, medicated defendants may be denied a fair trial if jurors do not see their natural demeanor at trial or execution decisions, or at the execution decision stage. Okay, so what about the intellectual developmental disability, so the IDD defense? So in Atkins versus Virginia, as I mentioned, death penalty for defendants with IDD was deemed unconstitutional because of their cognitive limitations. Limitations on impulse control, suggestibility, and a potential desire to please. They were judged to have difficulty understanding the legal boundaries of their actions. They might be vulnerable to demands to engage in criminal acts. They might have difficulty understanding their Miranda rights, more willing to confess, sometimes falsely, in response to pressure, and might be unable to work effectively with their attorneys. So what are the legal definitions of IDD? Well, following Atkins, most states relied on this fixed arbitrary IQ test cutoff point. So if you were greater than a 70 IQ, you didn't have IDD, and if you were less than a 70 IQ, then you did have IDD. So it was rather random, and psychologists did not, and still do not, agree on the kind of cutoff point on an IQ test. But then in 2014, there was a very important case where a mother whose young child had been determined that they were not IDD because of this cutoff point. brought a Supreme Court case, and it was found that having this fixed cutoff was unconstitutional. So then the states expanded their cutoff points to 85 to 70, which really was not based on any empirical information. Other states like Texas developed their own criteria. For example, did family or friends think the person was mentally retarded? Did informants indicate that the defendant could lie effectively? Have defendants shown leadership, or are they led around by others? Obviously not strict criteria. Then in 2017, Moore versus Texas decided that states had to use legitimate diagnostic criteria for defining IDD. And this included not only intelligence tests, but adaptive living tests. You know, how adaptive are you in solving problems in everyday life, and a developmental history. And that becomes very important, especially for marginalized populations. So what's the moral fallibility in diagnosing IDD for psychologists in capital cases? First of all, definitions of IDD continue to differ by state. Most psychological tests are not designed to assess state definitions of IDD. Psychologists do not agree on the appropriate intelligence test to use or cognitive criteria for IDD, or whether or not there is any cutoff point or range of cutoff points. And what's critical to the definition of IDD is that there is a developmental history. That is, when the child was in grade school or maybe middle school, that there was some psychological or medical history that they had cognitive problems due to brain injuries or some other test. But the problem with that is that poor people or less educated people may never have gone to a professional to be able to get a test of their cognitive abilities when they were young. Finally, standardized tests for intelligence are typically based on white, English-speaking, US-born, middle-class populations, and not on poor immigrant or other marginalized populations, which also means that it's difficult to apply a standard for that test. And finally, tests of adaptive living are also questionnaires. So they never observe the defendant in a natural environment to really see the extent to which they can adapt to everyday life. Okay, so remember, the next phase that psychologists are involved in is predicting violence for execution, sentencing, if a defendant has been found guilty. So the criteria for predicting future violence during sentencing also often, depending on the state, relies on what's the magnitude of potential harm? Are they likely to murder somebody again? What is the likelihood of harm? And that's usually based on their history of acting on violent thoughts. Is there an imminent danger of harm? And how frequent has their violent behavior been in the past? So there are inequities in prediction of dangerousness related to sentencing in capital cases. First, statistically, the younger the defendant, if the defendant is a male and has a history of violence, that's the best predictor of future violence. And that's usually gotten from whether or not somebody has been in a criminal court, whether or not there's military records or other disciplinary measures. So poor and ethnic minorities are more likely to be criminally charged and therefore more likely to have a history of violence. Research indicates that there's only moderate levels of agreement and that only perhaps a 50% or a chance rate that psychological experts can predict dangerousness, or whether somebody will commit a crime in the future, and that statistical and actuarial information, which is actually better than a psychologist's prediction, are fundamentally non-psychological in nature. So now I'm going to turn to just some of the facts about the inequities in capital cases. And as you can see, I'm kind of building up to the fact that psychologists' involvement in capital cases is in fact justifying and defending a course of action that violates human rights. So what are death penalty statistics? Since 1970, 1,565 men and women have been executed. 2,500 are currently on death row. And as of 2023, 190 innocent people on death row were released. And it's unknown the number of innocent persons still on death row. You need money to have an attorney to continue to argue your case, or you need a celebrity to continue to argue your case. In addition, racial minorities and lower socioeconomic status individuals are more likely to receive the death sentence. There's also inequities in executions. In 2022, 18 men were put to death in the United States, but more than a third of those execution attempts were mishandled. They were boggled in some way. What's also inequitable is that most executions are only concentrated in 5 states: Texas, Oklahoma, Mississippi, Arizona, and Missouri. And finally, in a recent study by Baumgarten in 2022, they found that the level of racial resentment in a state was related to the number of death sentences handed down on Black people. So what are arguments for psychologists' involvement in capital cases? Well, the first argument is the US law provides adequate legal protections. Under US law, criminals have the right to an attorney. They have the right to habeas corpus, which is the unlawful and indefinite imprisonment. And they have a right against self-discrimination. However, counter to that argument is that it assumes that all capital case defendants, irrespective of their socioeconomic status, their race, ethnicity, their immigration, and mental status, have equal access to well-qualified attorneys, that courts fairly grant habeas corpus briefs, and that defendants clearly understand and are given fair opportunity to exert their rights during arrest and interrogation. Argument 2 is the assessment neutrality argument. Assessments of insanity, intelligence, and future violence, though flawed, are neutral. They do not determine whether a judge or jury will sentence a prisoner to death. So the counter argument is that this is naive, since the jury is relying on the presumed expertise of the psychologist to inform their judgments. And it is rather a diffusion of responsibility, deflecting the psychologist's responsibility for the inhumane actions of the state. The third argument is, if we don't do it, others will. So this argument says that despite flaws, psychological expertise enhances the accuracy of assessments, which would otherwise rely on capricious and non-professional judgments. However, as we've talked about, legal corrections to rectify flawed psychological evaluations are often limited. There's a lack of funds for collecting evidence contradicting a psychologist's testimony. There may be a lack of funds for appeals. There's a lack of competent legal aid attorneys, and somebody may be put to death before they have their final appeal. Also, I think that counter to this argument of, well, if we don't do it, others will, is the question of whether or not if psychologists boycotted capital cases, would it decrease executions? Well, there is evidence that boycotting does work. In 2013, the European boycott of death penalty drugs lowered the rate of executions in the United States. And similarly, when Pfizer blocked the use of its drugs in executions, Arkansas executions were halted due to a lack of these drugs. So now I'm going to take you into how the American Psychological Association handled post 9/11 involvement of psychologists in harsh interrogations. And I'm taking you there because our ethical standards drew upon this to be revised to talk about human rights violations. So what was the post 9/11 challenge? Well, since the 80s, APA has endorsed the UN Convention Against Torture, which prohibits torture, including waterboarding, exploitation of phobias, and other forms of harsh interrogation. However, following 9/11, the Bush administration determined that some of these harsh interrogations were not torture and thus were lawful. Now, at the time, the pre-9/11 version of the APA Ethics Code stated that if there was a conflict between ethics and law that was unresolvable, the psychologists had to present their case to the court. But if the court decided that there was a legal need to protect the defendant or make sure that the legal requirements were served, that the psychologists could adhere to the requirements of law. At that time, the underlying assumption was that laws were humane. In addition, the kind of case that this code was related to was whether or not a psychologist could release confidential information. However, during the 9/11 aftermath, psychologists working for the CIA designed, there was only 2 psychologists, but they designed and supervised how to overcome detainees' torture resistance to harsh interrogation. The CIA psychologists defended their action based on this pre-9/11 ethics code standard that said, when there's a conflict between ethics and law, you can follow the law. So this created a great controversy in the American Psychological Association. Half the membership left. So when the activities of the CIA psychologists became public, members of the APA asked the organization to take a strong stand against psychologists' involvement in harsh interrogations. But for several years following the CIA revelations, APA policies did not have a definitive prohibition against indirect participation in harsh interrogations, arguing that the psychologist's consultative role, that is the CIA's role in training the military how to get over resistance to torture, had an information gathering role and was therefore ethical. One reason for APA's reluctance that came out in a court case was the fear of the governing board that grants and other forms of financial support from the DoD to the organization would be effective if they took a definitive stand. So it wasn't until 2010 that APA voted to amend the standard 1.02 so that even when there was a conflict between ethics and law, however lawful the law was, psychologists could not be involved in the activity if it would justify or defend the violation of human rights. In addition, they added to standard 3.04, which was avoiding harm, that not only do psychologists not participate in, facilitate, assist, or otherwise engage in torture, but in any other cruel, inhuman, or degrading behavior. So, finally, they've also added that psychologists can only provide services in settings in which torture and other cruel, inhumane, or degrading treatment or punishment occurs if they work directly for persons being militarily detained or an independent third party seeking human rights protections for the detainee. So what is the APA's position on psychologists' involvement in the death penalty? So while individual forensic psychologists may refuse to take on death penalty cases, APA has not issued a statement on psychologists' involvement in capital cases per se, nor has there been any governing council discussion on the application of the 210 Ethics Code standard invoking a human rights prohibition to psychologists' involvement in capital cases. So why does APA have no position on the death penalty? Well, members' moral protests against involvement in torture was strengthened by an underlying bias against many members in the military, in the organization, against and distrust of the military. and the fact that military and service psychologists made up only a small proportion of the membership. By contrast, forensic psychology and psychology and law have a very large membership in APA. And forensic psychology is a highly lucrative field. And although few forensic psychologists may have the opportunity to participate in capital cases, an APA position against participation may create tension with politicians from states who are in favor of the death penalty, and these politicians are needed when APA is lobbying for inclusion of psychologists in Medicare and other government programs. Or it might make attorneys and courts who would turn to other mental health professionals for testimony in these cases. So should APA apply? Well, the APA, the Ethics Code on Human Rights to psychologists' involvement in death penalty cases, I certainly believe it should, for the reasons that I've tried to summarize. There are inconsistent state definitions for criminal insanity, for IDD, for understanding execution and future dangerousness. There's lack of agreement on and inconsistency in psychologists' use of measures to assess these factors. There's continued social inequities in arrests for capital crimes and death penalty sentencing. And all of this creates an unfair legal system in which participation of psychologists helps to justify and defend the continued violation of defendants' human rights in death penalty cases. And I'm looking forward to questions and discussion after Alison's talk.
All right, thank you so very much for that. So I want to remind everyone in the audience to please submit any questions that you have via chat, and you can go ahead and submit those at any time to me as a private chat.
Am I still sharing?
Yes, you are still sharing.
Okay, let me.
And so we'll have you stop sharing.
As soon as I can stop share. Okay, there we go.
Okay.
Good.
And now I will hand it over to Alison.
Hi, everyone. My name is Alison Reiheld, and I'm really happy to be joining you today. I do have some slides to share, and if we are very lucky, there will be some audio clips as well, and if not, I will tell you what they contained. All right. So I'm going to have to share screen here. Give me just a second to do that thing. All right. Stephen, can you please confirm for me that you can see my title slide?
Yes, we can.
Okay, fantastic. Thank you very much. All right. So I'm gonna ensmallen all of y'all so that I can see my own slides a little better. I will be talking today about some information from my Trans Health Ethics project, which in which I did interviews with trans folks about their ability to access healthcare. But more importantly, I think that there are some things about conscience and the provision of healthcare that are becoming extremely important in today's legal climate, as more and more states make it literally illegal, not just disincentivize it, but make it literally illegal for clinicians to provide care to trans youth. So without further ado, I'm going to hit some background first, because we need to get on the same page with each other about some terms that can sometimes be a little confusing, where sometimes in presentations on this sort of thing, it's assumed that everyone knows what they're talking about, but in fact, we might have different definitions. So first, let's take a look at some basic terminology. The first of these is the standard meaning of transgender, which is someone whose gender presentation does not match the social gender norms for the physiological sex they were labeled with at birth. So, for instance, this sometimes might mean that a person who was assigned female at birth now is a boy or a man, or that a person who was assigned male at birth now is a girl or a woman. But transness does not necessarily follow this sex gender binary. Just as cisgender girls like me can reject norms of femininity and move through the world as tomboys, as I did when I was a kid, not all trans folks want to either be strongly feminine or strongly masculine. There's a wide range of transgender presentation and a wide range of what kinds of support and care trans folks want or need access to on an individual basis. So there are three kinds of support and care that are distinct from each other, and we need to understand them to go forward. There's gender affirming care, which is what most people think of when they think of the care that trans folks need, quote unquote, right? These are conditions or care which pertain to helping a transgender person's body and their gender to align in order to reduce or eliminate the distress caused when there is a conflict between body and gender. This can be internal conflict, it can be external conflict. So this includes things like, for instance, puberty suppression for teens, hormone therapy, various surgical procedures such as jaw shaving, or even talk therapy to help with mental health issues, but also speech therapy to help with the pitch and timbre and cadence of voice so that it reflects what the trans person wishes to reflect. This is not an exhaustive list, it's just an illustrative one, and trans folks pick and choose among these for whatever is healthiest for them, assuming, of course, that they can find clinicians to provide this care. Trans folks also typically seek social transition, which involves non-medical measures that contribute to trans folks' well-being. So this can include bringing gender identity and gender markers on state ID and other legal documents into alignment in order to socially reinforce the trans person's identity. It can also include having access to the bathroom that accords with their gender. So using a bathroom discordant with one's gender can actually lead to distress and even assault, as other users of the bathroom see the person as being the wrong gender. And social transition also includes the trans person being allowed to wear gendered clothing of their choice, to style their hair and their accessories as they choose, and to go daily by their own name and pronouns. In addition, trans folks need the same kinds of healthcare that anyone needs: treatment for broken arms, for asthma, for depression, for high cholesterol, for high blood pressure, for diabetes, or for the various strains and pains of everyday living. And hopefully, eventually, if they survive, aging. All three kinds of care can be life-saving and illness or morbidity reducing. And yet it's hard for trans folks to access gender affirming care, hard for them to access social transition and general health care in the United States. And it's much harder than for cisgender people, of course. In addition, many states are passing laws that are deliberately designed to make it harder, for instance, for trans youth to use the bathrooms that align with their gender, or even to access these kinds of healthcare. So if there's not access to these three forms of care, trans folks may engage in self-harm from distress, they may experience suicidality, and they may be subject to assault and other forms of violence. So why do trans folks so often have difficulty accessing this care? Well, there's a whole host of reasons, only some of which are the new hostile legal climate reasons. First, some clinicians believe that caring for trans folks is, quote, too complex. I've heard this one many times from people who don't believe that they're acting out of any kind of bigotry at all. They believe that it requires specialized knowledge to care for trans folks, and it may actually turn away trans folks who have medical conditions they know how to address in non-trans folks, from asthma to broken arms. Some clinicians also get awkward and don't seem to be able to handle normal clinical interactions with a trans person the way they would with a cis person, largely due to ignorance and lack of familiarity. And some clinicians simply want nothing to do with people they see as either subhuman or as inherently difficult patients. Other clinicians have relevant specialized skills for gender affirming care, like endocrinology or plastic surgery, but they aren't interested in learning how to deploy these for gender affirming care. In addition, office staff at clinics may be unprepared for someone who doesn't fit the gender binary in voice or appearance, whose legal documentation doesn't match their gender, or any other aspects of care for trans folks. And really importantly here, trans folks still experience employment discrimination in many US states without explicit legal protections that cover them. Affordable health insurance, as you probably know in the US, is still largely accessed through your employer. And trans folks are even less likely to have affordable health insurance as a result than cisgender folks, even though the passage of the Affordable Care Act of 2010 was supposed to expand access to health insurance. Because the Affordable Care Act still has most health insurance in the US going through employers, employment discrimination still affects trans folks' access to care. And then finally, as I've mentioned, the new increasingly hostile legal climate restricting or banning access to gender-affirming care can make clinicians worried about general treatment for trans folks as well. And so because of this, many trans folks fear seeking medical treatment. In Canada, the Trans Pulse survey found that 52% of transgender people reported trans-specific negative experiences in the ER. The European Union's Agency for Fundamental Rights surveyed trans folks and found that 22% of trans folks who accessed healthcare services in the prior year felt healthcare personnel discriminated against them because of being trans. And the US Trans Survey by the National Center for Transgender Equality routinely finds that about 1/4 of trans folks in the US avoid seeking healthcare out of fear for negative interactions with providers. In Canada, the Trans Pulse survey found that 20% of trans folks avoided even emergency room visits out of fear of how they would be treated. So in my trans health ethics project, I conducted rich, long-form, open-ended interviews with St. Louis area trans folks regarding their experiences seeking healthcare. Every interview began by asking participants to engage in free listing. I'll let a few of the respondents' own voices do the speaking. Permission to use or refuse use of voice recordings was part of the informed consent process for this study, and every participant was asked right at the beginning whether I could use their voices or not. I only use here clips from the folks who said yes. To the right, you can see a word cloud based on the spreadsheet into which all participants' responses were placed. As usual with a word cloud, larger words equal higher frequency. You can see there's almost no positive thought here about seeking healthcare.
So what we're going to do now is something that you've probably heard of under the term word association. But in the literature for methodologies, they call it free listing because it's not just words, it can be phrases or whole sentences. So what words, phrases, or sentences spring to mind when you think about seeking healthcare?
Red fucking tape.
All right. Anything else?
Money I don't fucking have. I wish I was in Canada right now. But sarcasm aside, difficulty paying for things, and always having to navigate a stupid sea of referrals and bureaucratic BS to get a damn appointment.
All right, so that was Violet, who clearly had a lot of negative experiences attempting to access medical care. Here is Jefferson Pierce. And by the way, these are pseudonyms that the respondents themselves chose. These are not their real names.
Please list for me in your own words some words or phrases that spring to mind when you think about seeking healthcare.
Do I have to? Will I die if I don't? How much is this going to cost me?
Okay. All right. I note that none of those have what we might call a positive emotional content to them.
Absolutely not.
Okay. So.
All right. And then here we have participant 13, who when I asked about a pseudonym said, if I can't use my own name, I have no name.
Okay. So please list for me in your own words some words or phrases that spring to mind when you think about seeking healthcare. Anything that you think of.
Embarrassing, humiliation, judgmental.
Yeah.
Oh, yeah.
All right.
So what we can see here is that there are really corrosive effects on trans folks' ability to access healthcare from the kinds of things that they experience. They just don't trust going into clinical settings. And they have some good reasons not to trust that. because they may experience discriminatory treatment right from the get-go. One of the participants that I interviewed said that they were told when they attempted to make an appointment for general health care, quote, "We don't treat transgenders," unquote. Another described going to the doctor as like continually trying to argue that you are a member of the human club and never being sure you've actually convinced anyone until you find that you do or do not get the health care that you came in for. All right, so what does this have to do with rights of conscience? Well, it takes actively working to provide care to trans patients, for trans patients to have access to destigmatized care. You need to retrain your front office staff. You need to rethink how you talk with them during clinic visits. You need to gain the skills. You need to sometimes redo your even your medical records software so that it allows more than just a gender or sex binary option, and so that it allows names and pronouns, not just assumptions about those things, to be entered into the system. This kind of provision of care is often based on conscience when the profession in general doesn't prioritize it, when medical record systems are not designed to account for it. And this is especially the case when provision of care becomes criminalized, as I will talk about more shortly. So one of the things we need to think about here is something that medical ethicist and obstetrician Lisa Harris has pointed out, namely that while there's often a protection for conscientious objection to performing medical procedures, as with abortion, there is no corresponding protection for the ways that conscience drives people to provide care. As Harris argues, there is such a thing as conscience-based claims for offering care rather than for refusing to provide it. And the persistent failure to recognize abortion provision as conscientious has resulted in laws that do not protect caregivers who are compelled by conscience to provide, in her argument, abortion services. And that contributes to the ongoing stigmatization of abortion providers and leaves theoretical and practical blind spots in bioethics with respect to positive claims of conscience. So while Harris is talking about abortion, I'm going to take her points shortly and put them into the trans healthcare context. All right, so back to Harris for a second. Harris points out that there are no conscience exemptions to the Mexico City rule, aka the global gag rule, that is typically reinstated by each Republican president immediately upon taking office, and that prevents family planning services receiving US funding anywhere in the world from discussing abortion. Typically, when Democratic presidents take office, they repealed the global gag rule. Nor did state laws prohibiting abortion before Roe v. Wade in 1973 make it unconstitutional to prohibit access to abortion. Right? I mean, those kinds of state laws didn't protect rights of conscience to provide abortion, right? But after Roe v. Wade, we have these protections for people who do not want to participate in abortions. So imagine what it is like for trans folks to seek care in the current legal environment and for clinicians to have to decide whether to provide it. It's simply getting harder to get gender affirming care. What we have here is a chart from ABC News on the 1st of this month, March 1st of 2023, on the states that have already banned gender affirming youth care. That is the states in dark red here, all right? And those are at least 8 states: Alabama, Arkansas, Florida, Arizona, Mississippi, South Dakota, Tennessee, and Utah. And so again, this is for trans youth to get access to gender affirming care. All the other states that are in this kind of peach color here or pale orange are considering such bans. And all the other green states either have no ban under consideration, no ban passed, or actually have explicit protections for trans patients so that they will be able to continue receiving this care. So while implementation of some of these laws is currently blocked as legal challenges work their way through the courts, as with Alabama and Arkansas, others are going into effect. Clinicians, patients, and families are planning ahead. For instance, families with trans youth living in the dark red states are, according to surveys, already considering whether they can afford to move to any of the dark green states that have protections or no bans under consideration or in place. In at least 23 other states, right, these are the peachy ones, state legislators are considering or have introduced bills that would similarly restrict access to medical care for trans youth. And here's one of the kickers. At least 3 of these states are targeting people up to the ages of 21, not just 18, and even 26. And some of them are criminalizing or attempting to criminalize gender-affirming procedures. Some of the most restrictive bans and punitive bans are being proposed in the state of Oklahoma. So I'm going to go through 3 of these so you can see the kind of environment that clinicians are facing. In Oklahoma, SB 3 already required hospitals receiving American Rescue Plan Act or ARPA money to stop gender-affirming care. Oklahoma University Hospitals was the biggest provider to comply because continuing to give care would have cost the hospital $39.4 million in ARPA funds. HB 2177 in Oklahoma would stop all hospitals that get public money from providing gender-affirming care to minors. A clause buried in the bill would also prevent health insurance in Oklahoma from covering gender-affirming care for anyone of any age, which means de facto trans adults would then not be able to access care because they'd have to be able to pay out of pocket for it, and such care is horrendously costly. This bill also could affect social supports if it were to pass, because it contains a clause reading, quote, a physician, mental health professional, or other healthcare professional, which could include a school nurse, just keeping that in mind, shall not knowingly engage in attempting to alter the appearance of or affirm the minor's perception of his or her gender or biological sex. Also in Oklahoma, Senate Bill 129 would make it a felony for anyone under the age of 26 to access gender-affirming care in the state, and felony charges could be levied against any clinicians who provide such care to anyone under 26. And then even referring someone to a provider in another state could involve loss of licensure within the state of Oklahoma, and thus loss of livelihood, in addition to possible penalties, financial penalties like fines. So we'll have to see what comes of these, but already clinicians in states with new laws restricting their ability to provide care to trans youth are facing devastating moral questions, not unlike those faced by clinicians in states with abortion bans prior to Roe v. Wade and even now. What does my conscience demand I do in the face of laws that attempt to punish me for providing this care? So suppose that a clinician in Oklahoma, Arkansas, Alabama, or other states with these kinds of laws feels compelled by conscience to provide care. How can they make this choice when their right of conscience to provide care is not protected in the way that rights of those who object to providing care have their rights of conscience protected? What we have here is a case of deliberate choice architecture as enforced by the state legislatures. Now, choice architecture is the set of incentives and disincentives that shapes our choices. So when you're a teenager, your parents say you have a curfew of midnight. You say, why should I be back by midnight? They might give you a reason for setting midnight as the deadline, or they might affect your choice architecture by saying, if you're not back by midnight, you will lose certain privileges. Right? That provides a set of incentives and disincentives that shapes your choices. You can choose to accept the disincentives and act anyway, right? But that becomes something that shapes your choice, and other people can shape your choices in this way. These choices in the choice architecture around you make it easier or harder to do the right thing, easier or harder to do the wrong thing. And we've got a powerful choice architecture here with trans care and this growing body of laws. Clinicians living in states that use or are considering using criminal penalties, licensure removal, or fines will see this as a powerful sign that the state does not respect conscience rights to provide medical care. In fact, it is a powerful sign of exactly that. The state is making it harder for them to do what they believe is right, and social pressure is making it harder for them to do what they believe is right. This also creates a subtle permutation on conscientious refusal that Harris does not address, but which I've found myself thinking about every time I think about her article. Conscientious provision of care to the patient is, in some cases, conscientious refusal directed towards government and other institutions, including their employers. In other words, conscientious provision of care in the face of laws preventing a clinician from doing so becomes conscientious refusal to comply with an immoral law. And it is certainly conscience that motivates providers in the vast majority of these cases, as well as in the face of social stigma. In speaking about abortion, Harris notes that abortion providers often face severe harassment, even where it is legal, including death threats and on rare occasion assassination attempts that sometimes succeed. Moving beyond reproductive health care to our use case of trans care, we can see that this is the case with many, maybe even most clinicians engaged in providing trans health care, especially to youth. In fact, just a few months ago, Time magazine published a short article reviewing the kinds of harassment that gender-affirming care providers can face, especially when they provide care for trans youth. What follows is an extended quote. Only a small group of pediatricians provide such care in the US, and in this political context, those who do are often finding themselves at the receiving end of growing harassment, even as research confirms the potentially life-saving nature of the work they do. Demonstrators have organized protests outside clinics. Billboards have been rented spreading disinformation about affirming care, including one near a children's hospital. Pediatricians tell Time they have received threatening mail, have been impersonated online, and have feared for their safety. And they worry such harassment campaigns could have a devastating impact on the ability of young people to access crucial medical care. Time has spoken with numerous providers who say they've witnessed a rise in harassment in the past 2 years, whether via in-person protests, online threats, and cyberbullying, menacing mail, attempts to cut their research funding, or even remove their medical licenses. Other gender-affirming pediatricians with whom Time spoke refused entirely to go on the record, citing fears about the risk of violence against them and their families. Dr. Brandon Hill, the former president and CEO of Planned Parenthood Great Plains, which operates in Kansas, Missouri, Oklahoma, and Arkansas, says he's been contacted by children's hospital administrators in major cities across the country, asking what trainings he gives abortion providers to prepare them for intense backlash and harassment. Quote, this stuff isn't new. The tactics that these anti-trans care folks are using have been used to target abortion providers, Hill explains. But I don't think we ever thought of this being something where protesters would be outside of adolescent health centers, ever. Unquote. Thus ends the extended quote from the Time magazine article. In the face of such harassment, whether for providing reproductive health care or gender-affirming care, clinicians provide care because they are driven by conscience. Sometimes that conscience drives them to do so in the face of intense harassment and threats, and sometimes in the face of legislation that can actually penalize them for providing such care. In the latter case, conscientious provision also constitutes a conscientious refusal to follow the law. This complicates our picture of conscientious refusal and of rights of conscience in medicine generally. So I haven't solved anything, but I've given us a lot to think about. Should rights of conscience be seen to include not only refusal, but also provision of healthcare? I think so. Should state laws protect both sides of the conscience coin? I think so. But if so, don't laws punishing clinicians for providing healthcare, especially healthcare considered standard, recommended evidence-based medicine for certain folks with certain needs, don't those kinds of laws profoundly violate clinician conscience, as well as harming the targeted patient groups? Yeah, I think so. What I ask of all of us is this, that we think about provision of care as a flip side of refusal of care. That we think of these laws as not just targeting the patients and the treatment they want, but also as targeting clinicians and their conscience. And then a final note to think about, looping this back to the issue of abortion. What does all of this mean for clinicians practicing in states that have forbidden abortion since Dobbs v. Jackson in 2022 last year overturned Roe versus Wade, which was the law of the land since 1973? All in all, between the trans care issues and abortion care issues, I think we're going to see the confluence of clinician conscience, professional ethics, and criminalization of healthcare playing out in coming years here in the United States. And I think it's going to be very, very hard.
And so I want to get us started here with a question about like how we're thinking about the role of these professional organizations. So it seems like there's all these different layers here. There's the There's the law and, the current legal and political environment. Then there's also the role of these professional organizations, either the APA or the Academy of Pediatrics or the American Medical Association. So how should we think about the role of these professional organizations here in terms of protecting conscience or advocating for particular kinds of values or things that they think are important?
Would it be all right if I took a first stab at this one?
Sure.
All right. So, the American Academy of Pediatrics, various organizations governing obstetrics and gynecology, and also endocrinology are pretty much on board with the idea that trans folks should be able to access gender affirming care, that it's better to attempt to reduce suicide by providing access to these things and assault and self-harm than it is to try to prevent suicide, self-harm, and assault by however many other ways you would have to do that, right? So people who are clinicians who are wanting to provide this care are going along with their professional organizations, not going against them. But those professional organizations don't make the laws. They advise on the laws, right? State legislators can summon them to give testimony in front of the legislature, and then they can flat out ignore it, right? They can do this at the level of the medical licensing boards. They can do this at the level of various Senate bills or House bills. Right? So what is the role of professional organizations? Well, I think that professional organizations should defend rights of conscience. I think they should expand that defense from beyond just conscientious refusal to conscientious provision. I think that some of these subtleties are pretty clear here. And they have the ability to gather resources from individual members in order to engage in activism and advocacy through solidarity. But again, they don't have the kind of power that legislators have. They don't have the kind of power that the licensing boards have. And so if the legislatures and the licensing boards don't frankly give a darn adequately about what those professional organizations say, much less about the testimony of individual professionals who provide this care, I'm sometimes feeling a little hopeless about what their role can be. But that doesn't mean that they roll over and stop fighting just because they don't have the unilateral power to make these kinds of changes.
So a quick follow-up actually to that. So asking out of my own ignorance here. So what stance have they typically taken on the conscientious refusal question? Have they been supportive of conscientious refusal when it comes to, say, the reproductive issues?
Yeah, and there's a lot of leeway that they support giving to clinicians. The American Nursing Association, the American Medical Association, and more have their own codes of ethics. And, they generally agree with something as broad as this, so long as it is not really obviously bigoted and discriminatory, you can choose whom to serve. That's embedded in the AMA code of ethics, right? You get to choose whom to serve, what kinds of procedures to provide. And there has typically been support for this idea that, if you work at Washington University hospitals in St. Louis, they shouldn't be able to force you to perform an abortion if it is against your rights of conscience. And in that sense, there's kind of this alignment between a lot of these professional organizations' thoughts on conscientious refusal and on the sort of leeway, the latitude that providers should have to choose who they treat and what they treat and how they use their skills, right? But there are a lot of ways that kind of latitude can ease into just not treating at all. So while I restricted this presentation that I gave you guys, I have a lot of other arguments for why providers ought to be making decisions to treat these folks and to offer these kinds of treatments. But the AMA Code of Ethics allows doctors to say, I'm not going to do that thing, right? I, an endocrinologist, am not going to offer these kinds of hormone replacement therapies for the purpose of gender affirming care. But the similar kinds of protections often aren't advocated for as heavily as I think they ought to be. And I'm going to be interested to see what the American College of Obstetrics and Gynecology is developing as the impact of Dobbs v. Jackson Women's Health overturning Roe v. Wade really starts to play out.
All right, thank you. Celia?
I have certainly a different perspective. Number one, I don't think we should be giving organizations a pass, medical organizations a pass. I think they could come out against conscientious objection to treatment. And I also think, at least knowing some of the medical codes, and it's certainly the American Psychological Association code, is that you are permitted to not provide services if you are not competent to provide those services, but you cannot discriminate. And so, I agree with some of what Alison was saying, that some people don't have the skills. And so they say that they don't have the skills. And so that's an excuse. But universities and medical schools can also include in their training trans health type of training. They can include, so I think the organizations can do a lot more. Look how the APA and the American Psychiatric Association and the American Medical Association took a stand against torture. They were really specific about harsh interrogations, and that has really limited any involvement of psychologists, and medical professionals in these activities. In addition, as somebody who chaired a state licensing board, we're not necessarily void of influence from our own professionals. So it really depends. Some states, the licensing board is all politicians, they're all politically appointed, but in other states, they're actually coming from the profession. And so there certainly can be pressure, as I experienced in some things when I was chair of a licensing board. We can put pressure on the state in terms of fighting against regulations or promoting certain regulations as fair and equitable. So I would like to see more of the medical associations taking a position, for trans health, obviously for the death penalty. There are these political reasons why they don't, because they do have to lobby for the rights of their membership, and they have to lobby. And who are they lobbying? They're lobbying some of these states that are passing these kinds of bills. So I think there's a certain amount of self-interest that's also kind of preventing them from taking these steps.
Yeah, and just to respond to that, I think that's absolutely correct. I don't disagree with anything that you said, that the organizations can do more, of course. But if they're going to defend conscientious refusal, why do they not defend conscientious provision more strenuously? Right? And they do try to lobby against some of these laws, and they should continue to. And I would like to see that be more effective. But we've actually seen people go before the legislatures and plead and beg and bring forth all the evidence, and have legislators be utterly unmoved by everything from a trans kid saying, if I hadn't gotten this care, I would be dead now, to the experts and the organizations doing the lobbying. So I only mean to highlight the limits of that, even while we must make the professional organizations stand up for these rights, because individual clinicians are so weak alone against this apparatus.
And another follow-up.
Let me just say for a minute, Steve, that, also the ethics code can be very punitive. Just like we put into the ethics code that you're not allowed to torture, you're not allowed to do anything that's a violation, of human rights, or either defends or justifies it. And at least in psychology, many of the standards in the psychology ethics codes are adopted into state law. So, I wouldn't be as pessimistic. I'm pessimistic about the lack of action of these organizations for whatever fears that they have. But I'm not as pessimistic about the power that they have for their own constituents if they'd actually implement that power.
So I'm actually also curious about, so to follow up and to Celia and Alison, if you want to add to this as well. So when we're thinking about those licensing boards, once again, out of ignorance, like I'm not entirely sure how, those bodies actually function when it comes to issues of whether to punish a provider or how to punish them. And so, there's this, if a state law provides that somebody can have their license removed for providing a particular type of care, do licensing boards potentially have the power to say no and to not strip somebody of their license when providing care? Potentially, could that be another form of conscientious refusal, but only for an entity that has a little bit more power than the individual clinicians?
That's a great point. Having sat on the licensing board, usually we wanted to be more punitive than we were allowed to be, unfortunately. But I think there is the power, I think you're raising a great point in terms of licensing boards taking what Alison has been talking about, which is this conscientious stand not to, adjudicate by an inhumane and law that's in violation of human rights. And I think they could do that. And what would they risk? They'd risk being taken off the licensing board. And believe me, I've been in that situation. But we persisted. When you have a strong enough group of, your own field members to defend you against a state trying to get rid of people that are against it, it can be very successful.
So just a really quick point. I like this move in this question, Stephen, because one of the things it does is highlight that there are multiple moral agents here. My presentation focused on the clinician as the moral agent. Your first question focused on whether or not the professional organizations are moral agents. And then this looks at whether or not the licensing board is a moral agent. So just for the folks, playing along at home with this whole dance of ideas, that's a really useful question at all times, is who are all the possible moral agents who might be able to effect change and also possibly have obligations here.
Great. I really like that way of thinking about it. But I do want to shift to some audience questions here. And there's a couple of questions about the international context of the things that both of you are discussing. And so, Alison, in your presentation, you mentioned, Canada and the EU, there's similar issues there. I was wondering if you could say a little bit about how does the US compare to these other international environments when it comes to the provision of care in general. And similarly, to Celia, have other professional organizations taken a stance against the death penalty in different parts of the world, especially since the death penalty has less support in some parts of the world than it has in the US. So Alison, would you like to kick that off?
Sure. And I'll try to be short because I know there's some really interesting comparative stuff about death penalty between, say, Europe versus China, right? But with respect to trans access to care, the EU is not a single nation with a single set of policies or laws on this issue, and it contains some member states that are much more conservative than others on trans issues. Some member states of the EU have only recently allowed people to change their gender markers without having to, for instance, be sterilized under their sex assigned at birth, meaning have their reproductive organs removed. So for a long time, some of the Nordic states were requiring that in order to have your legal gender markers changed. In the US, you can have your gender marker changed. In many states, again, it's on a state-by-state basis, right? But in many states, you can have your gender markers changed without having to have already accessed any trans treatment, right? Depending on what the laws are, you can find local advocacy organizations in major cities that can help you navigate this. They will often have legal clinics several days a year to help people do this, right? But other states in the EU have made it very easy to change your gender markers. The UK has, of course, withdrawn from the EU in the famous Brexit controversy that happened about the same time that we were having major political upheavals in the US, 2016 and 2017, right? at around about that same time, there was sort of a movement towards more conservatism in the UK on access to trans care, and that has only steamrolled in the last few years, with a couple of high-profile cases where some trans folks who transitioned as youth, who received gender-affirming care as youth, publicly did a lot of interviews where they talked about their detransition and how they thought the process of receiving gender-affirming care harmed them. And so there are just a few cases of this, whereas there are thousands of cases where gender-affirming care was thought to be beneficial, where people haven't detransitioned or anything else. So in the UK, though, the debate has been dominated largely by the really high-profile detransition cases. And so what you have is people advocating for the National Health Service in the UK to change their coverage of gender-affirming care. And you have actually had an enormous amount of sort of delay and worry about approving these procedures, not only for youth, but for adults. The waiting time, last I heard, which was a piece written last year in the UK for adults to access the major urban gender clinics, was potentially up to a year for your first appointment. For your first appointment, right? So it's hard to get this care even when it's legal, partially because people are so worried about its misuse. And just as in the US, we have to look with attempts to crack down on opiate use, about how attempts to limit abuse actually impair legitimate use. We also have to look at that with access to reproductive health care, with access to trans care, and so forth. And I'm going to leave it at that and pass it on.
Well, I think with your question about international regulation, since 1990, only 11 countries has instituted death penalty, and among them is the US. Out of the 200 or some odd countries that there are, approximately 130 do not either, de facto or de jure have prohibited the death penalty. So I think what is so interesting and speaks to what does conscience mean in the United States, why have some states been so eager to do whatever they can to make sure they can implement a death penalty? And one of the things I found interesting was when I was looking at the map that Alison presented was how the 5 states that are doing the most death penalties are also those red states that are implementing these kinds of things. So I think we as, U.S. U.S. citizens and people who are living in our country, we really have to start thinking about what is our moral culture here? What are our values? And, why are we so eager to crucify the other or deny the other of their rights? And I think we really have to have some deep reflection on that as a country.
Yeah, that's a really interesting parallel there. And I was also sort of like thinking about some of the connections there between the death penalty and some of those things that came out in those interview clips. So in particular, I was thinking about being a member of the Human Club. And this seemed like another example where there's this system in place that tries to kick other people out of being a member of the Human Club and deny their humanity, deny their dignity. Any comments or reactions to that idea?
Yeah, so there's a book forthcoming from, I think, Routledge by Audrey Yap and Barrett Emmerich, in which they argue that if you look at North American carceral systems in general, Canada and the US, what you see is sort of a culture of disposability, where people who have made choices, in this case criminal choices, that take them sort of out of the mainstream social network, are no longer really fostered, nurtured, given ways, good avenues of reintegrating themselves back in. They're seen as disposable. So there's a kind of a culture of disposability of people who who aren't in the human club sufficiently because of their actions, right? They're judged to have taken themselves out of the human club. And then the idea that trans folks might be seen as not part of the human club because they're so deviant, right? Or that clinicians who help people to get gender affirming care are corrupting our youth or misleading our children or harming them in some way by engaging in, sometimes the rhetoric on this calls it permanent mutilating procedures, right? As though gender affirming care is like female genital cutting or something like this, right? That kind of rhetoric really creates this profound sense of otherness, this profound sense of creating the other as well. And I do share that worry. I think that's a kind of a commonality here. One of the things I have been sort of, in the moments when I stop having my professional hat on and just put my personal hat on about trans kids being denied access to gender affirming care, I think to myself, don't these legislators understand that people will die? Don't they care? And a friend of mine who is trans said, oh, they understand and they care, but it's not a problem for them because the trans kid isn't the one whose welfare they care about. It's the cis kid who isn't yet trans. And I thought, I'm going to have to think on that one because that hurts like the dickens to think that that's what people's mindset is. But I'm not sure how we can pass some of these laws about the death penalty or about what I'm talking about if we don't at some level think these folks don't count anymore.
Do you have any reactions to that?
I think what I said before was, very much in line with what Alison was saying, that we've otherfied, marginalized. I would say that I wouldn't globally say that people who commit crimes are considered not human, because people who commit crimes and are Black and are of color or are poor are considered not human, but those who are white middle class or have the access to the lawyers continue to be considered human. So I think we still have to think about what these kind of not only systemic but cultural and value issues within our country, really direct how these inequities occur.
Right. So I think this also brings us to another sort of issue here. And I think this will have to be the last thing that we talk about. So I think implicit in this idea, one way of framing this is that some types of conscience are less, I don't know exactly how to put this, are objectively bad, right? And acting on some people's conscience, some people acting on their conscience might not merit protection, right? Especially since I think a lot of people who protest against, the gender affirming care for trans kids, they really do think that, it's harming children. They're wrong. And they're dehumanizing these children in the process. And I think, perhaps that's something that we can say, and perhaps that's something that organizations can speak to. Same thing when it comes to the idea of psychologists participating in death penalties. Some people might think that they're doing the right thing. They're helping to institute justice. They're helping be part of the system that they think is legitimate and rational. And maybe it's okay for us to say, no, that's not.
Do you want to take first go at this?
I'm not sure. I think it's given that I think what you're saying, Steve, I think, is that some elements of conscience are based on false facts. And those false facts or false beliefs can be considered immoral. They can be considered unjust. They can be considered not a legitimate form of conscience because they are not based on fact. I think so. When you say, pubertal blocking drugs are dangerous for transgender youth, that's not true. But so that's a false belief that if a physician is using that as an excuse not to use it, then that's not a conscientious objection that we should be honoring. I think it becomes more difficult in terms of this country's kind of valuing of religious values in very interesting and potentially inequitable ways, and that picking and choosing what religious values are considered to be conscientious versus those that are